The first case to come before us this morning is State of Ohio versus Larry Brown. Both sides will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant, please let me know when you get started if you wish to reserve any time. Please also do not use the names of any victims or minors, as we are live streaming this oral argument and it will be recorded and placed on our YouTube channel. We have read the briefs and we are ready to proceed when you are.
Good morning, Giovanna Bremke on behalf of Mr. Larry Brown. I would reserve 5 minutes of my time for rebuttal. And there's a lot to unpack here, so I may jump into that, but I'll try to reserve as much as I can. So again, Giovanna Bremke on behalf of Mr. Brown. The facts of this case are laid out in the brief, but I will point to the relevant facts. Mr. Fowler is the main witness here. Him and his brother, I'll refer to him as LS for purposes of the oral argument. They lived together as brothers in Lorain, and Mr. Brown came to visit them from Kentucky. Everything was going well. Mr. Fowler says he refers to him as his nephew. There was nothing out of the ordinary. They travel around to various places in the morning, and then get back to the home. And the LS and Brown start to what's referred to as horse playing. It's actually referred to as horse playing 19 different times, and I cite to those 19 times on page 4 of my brief, and that's significant later on. They start horse playing, sort of like wrestling down the hall. Fowler testified that he heard one shot. He didn't see a gun fired. He didn't see who it was, who fired it, who aimed it, where it was fired. And then him and Mr. Brown got into a vehicle, and at no point did Fowler make an effort to call 911, get assistance for his brother. And eventually they did end up at a bank where Fowler asked one of the employees to call 911 many hours later. The 5 assignments of error are, actually there's 6, 6 assignments of error. The first one is based on speedy trial. There was a motion to dismiss for speedy trial purposes, and that was done. There was initial counsel and then subsequent counsel. That was done by subsequent counsel. Mr. Brown was actually indicted on March 22nd, 2016, and his first court appearance was not until March 19th of 2019. So he sat for 32 months without seeing the inside of a courtroom. That was 44 pretrials, and 22 of which were final pretrials. And this case was set for trial 8 different times. At no point did he consent to his counsel waiving speedy trial, and he makes that clear. He also says—
Second, counsel, hang on. I want to back you up, and I know you have a lot to get through, but this is a really important issue here. When you say his first court appearance, do you mean, and I'm gathering this from the briefs, that's the first time he saw the judge face to face, correct?
Yes. I should clarify, I believe there was an arraignment where he may have seen a judge, but subsequent to that, the next hearing, between September in 2016 and March of 2019, there was no time he saw the judge.
Okay, there were a lot of court dates regarding his case where his attorney appeared, but not him in person. Is that correct?
Correct. Actually, 45 times, 45 pretrials, the attorney appeared. But
the other thing I want to ask you is, when you say that your client said at no time did he waive, was that in regard to his motion to dismiss for speedy trial that he said that?
Yes.
And how do you reconcile that with the signed time waivers? That's what I'm trying to figure out.
So he also says, and this is transcript page 75, that time when he gets into the courtroom, and the first time he does get into the courtroom, he says, hey, this is, I'm really glad to see you because, I don't want to be sitting here. I need to, go to trial. He makes statements that say that he would like, that he did not waive his speedy trial. He also indicates, again, transcript page 75, that he knew that if he filed a pro se motion, it wouldn't be accepted. So
but counsel, didn't he file a pro se motion or pro se letter that asked for another attorney?
He did eventually, yes.
But that was before this, though, is what I mean. Before this hearing in front of the judge and this speedy trial motion, he filed a motion to get his first attorney off the case. So that again is a little contradictory.
Well, I believe a lot of that motion, I don't believe was ruled on. Actually, the counsel came to the court and asked to be removed on the day of a trial. So still that motion was not addressed. So he knew that his pro se motions would not be addressed by the court. And so it's a very difficult situation if you're not seeing a judge. How can you, and your attorney's not respecting your wishes there, how do you get that across? For 32 months, he never saw a judge.
Okay, and just the last thing, I'll let you move on. How are we supposed to reconcile the statement from him that I never waived versus the signed waivers from his attorney? And, his attorney speaks for him. I mean, if he in fact was in this other room and not waiving and saying he wasn't, no, I don't waive time. No, isn't that something outside the record? How what we have in the record is the signed waivers. I'm trying to figure out how to deal with that.
So let's talk about that. So you do have in the records these waivers, but you also subsequently have this motion by the subsequent counsel. And that was his first opportunity to express this. I also cited the case Barker versus Wingo, which talks about, how speedy trial is sort of like a concept. And I know we always refer to it as number of days and a very strict number of days. But really, it talks about how, speedy trial and the, the different aspects of how this could really harm a defendant to sit. And, sometimes we think of it as an advantage because, for various reasons, but really it's not. And in that there's, an inability to defend yourself and how this can't be it has to, sort of be inflexible, and it has to be that there is, a concept of speedy trial. And just because there's, even if there is a waiver, there's not a forever waiver, things of that nature. So, even with trial with the counsel, even if counsel was waiving for 45 pre-trials, there has to be some sort of accountability for the other parties as well, the court and even the state, to bring this to trial, at least to allow my client to be in a courtroom to see if he expresses it. I would like to move on. Second assignment of error, that there was no instruction for lesser included. So there was a motion by counsel to ask for lesser included on count 1 and 2 which were murder, down to negligent homicide and reckless homicide, and counts 3 and 4, which is felonious assault, down to assault and negligent assault. I don't think that there's going to be a debate that these are lesser included, because obviously there's these 2 steps. There's not going to be much of a debate on the first step. What the court decided was that, that the second step essentially couldn't fit, and that was that, viewing the light most favorable to Mr. Brown, that the jury couldn't find him, guilty of the lesser included and not guilty of the originally charged indicted counts. All of this really stems down to the mens rea aspect of things and the purpose. So it's, to me, this is a very obvious case for lesser included, because there was, again, this description of horse playing 19 times. There was no, argument. There's no one testified that there, if, in fact, I think the quote from Mr. Fowler is everything was Gucci, which he referred to as very good. Everything between them, he referred to him as his nephew. Everything was going great, and there wasn't this, purposeful. So even if you believe Mr. Fowler's testimony, there still wouldn't be enough there for the purpose.
Counsel,
But again,
excuse me a minute. Didn't Mr. Fowler also say that your client said, I had to pop the MF? Would that indicate purpose?
And before you answer, I need to let you know you're at that 5 minutes. Go ahead.
I am. Okay. I knew this was going to be difficult with this many assignments of error, but yes, so there was a statement to that effect. Of course, that was after the fact. And again, Mr. Fowler, and this goes to my, manifest weight argument, he's not the most credible witness. But even if that's believed, because let's say it's believed, again, that's after the fact, and everything else would point to this horse playing, and that there was no indication of any anything that went afoul. So really, at least to present the jury with lesser included and let them decide that issue. The other assignments of error, there was an expert witness that was recalled. The importance of that is that this code message in the phone report would indicate that somebody else was in the home. He later was recalled and said that it wasn't that wasn't the case, that it was just an ignored call. The court cites to the State versus Velma, and which only deals with lay witnesses. This was an expert witness. And then, of course, sufficiency and manifest way of the argument. This court will review the record and ineffective assistance based on that 32 months of not being in the courtroom. I would reserve the rest of my time.
Thank you, counsel. Counsel for the state.
Thank you, Judge Hensel. Good morning, Judge Teodosio. Good morning, Judge Callahan. Brian Murphy, Assistant Prosecuting Attorney, Lorain County Prosecutor's Office, on behalf of the state of Ohio. Before I start, I want to clear up something in reviewing my brief in the statement of facts on page 4 that I wrote it's the first full paragraph. I'll read the clause that Brown signed 14 journal entries to waive statutory speedy trial time. Now this particular clause, between October 7, 2016 and July 19, 2019. I just want to be clear, because I wasn't clear in my writing, that those are the dates on which he signed the journal entries. Those are not limiting periods. I did not mean to intend or to imply that those are limiting periods. Those are the dates on which he signed the journal entries. Judge, with regard to assignment of error number 1, there were 6 trial dates by the state's count, not 8. The motion to dismiss itself is quite bizarre and unorthodox. It's handwritten. It's signed in 3 places by Mr. Brown's ultimate trial counsel, but it's also signed by Mr. Brown. This was probably procedurally should never have been granted. This was a hybrid representation. And by the way, none of these constitutional or statutory speedy trial arguments were offered there. This was a motion brought under Criminal Rule 48 saying dismiss the indictment, which there was no reason to do so. But even substantively, again,
let me ask you something for a minute. Putting aside the alleged hybrid representation and the no speedy or constitutional argument made below, just for a minute, in addressing opposing counsel's argument, you know, when you get to the constitutional evaluation and Barker, Wingo, you start talking about reasonableness. In what world was this amount of time reasonable?
In a world in which defense counsel continually waived speedy trial time, and in a world in which the defendant continually waived his speedy trial time. Judge, this isn't an instance in which nothing happened. This is an instance, you cannot blame the state of Ohio for not bringing a case to trial when time after time after time after time, defense counsel's waiving speedy trial time and saying, I don't want this to go to trial yet. That's what they're saying. We don't want this to go to trial yet. And if Mr. Brown really wanted to get before the court, he could have demanded that his attorney bring him to see a judge. He could have demanded that his attorney file something that says, bring Mr. Brown to the courtroom for a hearing. We need a hearing. He could have asked the judge, let's go on the record at any point during this period. Mr. Brown knows he could have filed something. He could have fired his attorney, hired another one, and had someone show up and said, enter a notice of appearance, bring Mr. Brown in. This is unfair that he hasn't come in. That's not what happened here. The state can't have a trial just because it wants to. The state was prepared for trial multiple times, the record shows. Like that part of the record where the assistant prosecutor said, we have plane tickets and reservations for somebody to come here. And that had to be canceled, I believe, multiple times. We'll sit down at a trial table, let's have a trial. But if the defendant's saying, I'm not going forward, I'm waiving my time, there's nothing more we can do.
Of course, the court could require the parties to go to trial.
Absolutely, Judge. And the state, as the record shows that the state was prepared to go forward. The record does not show that Mr. Brown and his trial counsel were prepared to go forward. Mr. Brown, don't forget, retained this trial counsel too. This was not appointed trial counsel either, the record shows. And by the way, whatever Mr. Brown said on the record isn't evidence. Okay, these are unsworn statements. This was not a speedy trial hearing either. Okay, so this is all unsworn stuff. It's just stuff that he's saying to the judge.
Opposing counsel led me to believe that Mr. Brown may have withdrawn the waiver, not using those exact words, but and may have insisted on a trial. Was there anything he said to the judge that that could fit that scenario? We can't hear you very well. Okay, go ahead.
I'm sorry. I don't believe that would equate to that, Judge. And if my memory of the case law is correct, I believe he has to do that in writing.
Thank you.
Or at least it needs to be an unequivocal withdrawal of the waiver, and that certainly was not unequivocal what he's saying there. And with regard to the statement that there's no forever waiver, frankly, that actually is just wrong. I mean, there are unlimited waivers. If they're not limited, they're unlimited. That's what this court has held. So those are unlimited. They're forever until you withdraw them and revoke them and demand a speedy trial and demand a trial date. With the second assignment of error lesser included offenses, I have no idea where the statement comes that there's not much debate about the first step. The state's brief makes perfectly clear that there is much debate about the first step, and that Mr. Brown is absolutely wrong about 6 of these offenses. Mr. Brown did not do the relevant legal analysis of asking for a lesser included offense at the trial court level or here in his brief. Each one of those offenses that's asked for as a lesser included offense needs to be compared to each of the offenses in the indictment, as the state did. I mean, there's a Supreme Court case that's dead on point, Owens, as far as whether reckless homicide is a lesser included of murder B. It's not. Now, that case came out after the trial, after Mr. Brown was convicted, but the Supreme Court's clear that this court's required to apply it. The Cost case is perfectly clear that negligent homicide is not a lesser included of murder A. There's very much a debate here. The only two that the state concedes at this point is reckless homicide and reckless assault, with regard to reckless homicide under the murder A and reckless assault under the felonious A1. And let's remember what the defense was. The defense was, it wasn't me who shot LS. That's perfectly clear from the defense's opening statement, in which his lawyer said that the evidence would show that Brown didn't shoot LS, that SF did, and that the evidence won't show that Brown even had a gun. You don't get to get lesser included, and you don't get to throw everything at the wall. That's what the case law says. You don't get to throw every defense at the wall and see what sticks. You get to choose your defense, and it's clear from that opening statement, combined with the two witnesses, by the way, that Mr. Brown presented, that his defense was SF shot LS, not me. And a reckless homicide and a reckless assault, lesser included to a second level, wouldn't even jibe with that defense. In addition to 6 offenses not even being lesser included offenses. The key sentence to take out of Owens is an offense that includes an element that another offense lacks can't be a lesser included offense of the other offense. So what the Supreme Court said there is, look at what you're asking to be the lesser included offense. If it has an extra element, it can't be a lesser included because the state was never required to prove that element. I mean, frankly, that's a benefit to the defense, because the defense can't prepare for some of these lesser included offenses as they're looking at it. They're not looking to serious physical harm. In the case of negligent assault, I believe, serious physical harm. When the state doesn't even have to prove serious physical harm to prove felonious assault under A2. We don't even have to prove an injury occurred, just an attempt to inflict injury. So there's much debate on the second assignment of error and whether lesser includeds are even in there. And Judge Callahan, to your point, I think you're absolutely correct that the statements made by, the statement made about I had to pop the MFer, pointing a gun at SF, telling him, let's go, let's get out of here. The look on Mr. Brown's face after having shot LS, as described by SF, he was enraged. The place at which he shot, that LS was shot, which was in the neck, chest area. I mean, you're hitting windpipes, the jugulars there, the lungs, the heart. I mean, the neck. These are major things, areas of the body that, if they're hit by a gunshot, are really likely to cause death. These weren't reckless or negligent. There was actions. There's no surprise on Mr. Brown's face, no concern, no remorse ever expressed. He was either guilty of what he was charged with, or he wasn't. It was either him or it wasn't him. 2 people walked out of that house. One of them shot LS, and the evidence is overwhelming that it was Mr. Brown. Just delving a little bit into sufficiency and manifest weight. Ending up in Baltimore, Maryland, where he's arrested. The gun's never found. His Mercedes-Benz car is never found. Turning the phone off in the area of Cleveland. To the assignment of error number 3, briefly, look, justice should prevail when a technicality can be rectified promptly. That's what this court wrote more than 40 years ago. And it applies in this case. You know, when you look at Mr. Witt's testimony, 2A versus the 29 service code, he made a mistake. First of all, the state doesn't even concede.
On that issue, I read the assignment of error. It talks about Mr. Witt being an expert. I read what was quoted from the judge when the judge originally, sounded pretty disturbed by this about the request to recall, and the judge referred to him as an expert. Was he called as an expert? Was he qualified as an expert?
I don't think so, Judge. I mean, the guy was a records custodian for a cell phone company. Frankly, all he had to do was certify the business records. And don't forget, the business records were entered as evidence. So had the jury looked at some of those service codes and went, whoa, this doesn't, the jury may have looked at some of those service codes on the tip sheet that was provided and said, hey, 2A doesn't match up and 29 doesn't match up. I mean, look, the trial doesn't only have to be fair to the defendant. The trial needs to be fair, period. It's fair to the state, it's fair to the defense, and it's fair to the victim. We have a dead person here. And that person has a right, his family had a right to achieve justice, to make sure that a fair result occurred here. That someone, if Mr. Brown indeed were responsible for LS's fatal shooting death, they had a right to expect that the trial would result in someone being held responsible if the proper person were charged. And the evidence overwhelmingly suggests that Mr. Brown was the shooter and he was the killer. And what the judge's ultimate decision and what ultimately happened was fair, it was right, it was just. We found out what the truth was with integrity. And that's what trials should seek to do and in order to preserve the sanctity of our criminal legal system.
Counsel, with that, I need to advise you that you have utilized your 15 minutes today.
The last thing I'd add is just making him an expert. We don't concede that, Judge, but the rule that Mr. Brown puts forth robs the trial court of any discretion and requires perfection of experts. And that's just not accurate. We don't even require perfection in trials. Judge Hensel, I apologize. We just ask that the judgment of the trial court be affirmed as well as the convictions. Thank you.
Thank you, counsel. Counsel for the appellant, you have 3 minutes and 42 seconds remaining for rebuttal. Thank you.
Great. So I did want to address the waivers, and I'll point your attention to the transcript, page 199, where the trial court judge even says that these, he refers to them as questionable waivers and said that there's obviously a number that were not signed by Mr. Brown. And that kind of acknowledges that these consents happened without Mr. Brown's consent. So again, when we're talking about a waiver, these were not, speedy trial was not knowingly waived by Mr. Brown. The state says that this motion, I'll admit it's an unusual motion, and but it does specifically address speedy trial. I don't think it's fair to say that it doesn't. His motion to dismiss, it specifically addresses speedy trial, and there was discussion on the record about the speedy trial as well. As far as the expert goes, while all he needed to do maybe was verify the business records, he definitely testified on things that only an expert would be able to testify on. The trial court makes that very clear of that. And in fact, apparently these codes were so complex that he couldn't even ascertain what they were. So it's certainly not the context of what a lay witness would testify to. He was undoubtedly an expert witness. And again, the trial court does admonish him, or when he's asked to be recalled, does make very stern statements about how unusual it is. Because I didn't get to the ineffective assistance, I would like to address that, just in saying again that Mr. Brown's counsel, again, was not respecting his wishes. That's clear in his first court appearance. He says that he asked his counsel that he be present at all hearings, that he didn't want to waive time, and that these wishes were not respected. Again, the standard there is that it prejudiced him. Undoubtedly, it prejudiced him. The time, and again, there's this case, Barker versus Wingo, and it talks about all of the prejudices to, all the prejudice to a defendant. It's not just, an advantage, or the time is in, to their advantage. So again, we would ask that you reverse the judgment and remand based on these 6 assignments of error.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to the parties to this appeal, as well as posted on the Ohio Supreme Court website.